Stephen A. Williams, president and founder of the creditrepairshop.com, and in today's video, we're going to talk about how to really dig into a court summons. It's going to be a very brief video. I want to show you something that I found inside of a court summons that basically showed that the debt collector potentially knew that the debt that they were trying to collect was past the legal statute of limitations to collect. I'm also going to give you a little bit about the backstory on this particular summons. This is someone from YouTube who came to me recently. They went to court. Now, let me listen to this story, because you got to understand that if you don't know your rights, the judge is not going to be there to help you. And as a matter of fact, in this particular case, they went to the self-help center, and they also went to the legal aid department. And this is exactly what happened. They did not even take the time to look at the court summons to see the potential issues within the court summons. If they would have just took the time with this individual, they would have found that this debt was potentially past the legal statute of limitations to collect. As a matter of fact, when this individual went to court, the judge actually stated that the debt could be past the legal statute of limitation, but because the individual didn't know their rights, they got a default judgment. So with all of that happened, and this individual getting a default judgment, the proof was sitting right there within the court summons. And I want to show you how you can identify these things. But you're going to have to scan the documents, and you're going to have to scan them a few times, because they write this stuff in a way that will get you emotional with the things that are really not relevant to you. And that's because they want to do that so they can get your mind off of the facts of the case. To them, the only facts that they want you to look at, which are half facts, because it's just the statements, and that they purchased the debt. Like they want you to look at that. Yes, it's a fact that this is a real statement. Yes, it is a fact that you did purchase a debt, but they don't want you to look at any of the other details. And some of the times the details could be right there within your court summons, giving you a 100% victory in your court case. So now with this one here, it states right here on this line that defendant defaulted by failing to make scheduled payments. The date of default was on or about February 10th, 2020. Now let me tell you, they cannot come into court and say on or about. Why would they try to make you be very specific on anything that you're trying to put forth as a defense? Any documents that you want to say that you believe are inaccurate? Anything that you want to state saying about you didn't do it or it's not your account? They want 100% proof on that. But they allow this debt collector to submit this court summons and state that on or about. Okay, so let's tear this apart. After doing the research, and the way that you do the research, just for that statement right there, there's a whole bunch of other things that you could research too. But let's just stick with this statement that they made right here. The individual found out that the debt that they made their last payment on was in 2018. For the state that they live in, the statute of limitations is 4 years. So let's count it up real quick. 2018 to 2019 is 1 year. 2019 to 2020, 2020 to 2021, 2021 to 2022, 2020. What? Did I get that right? 2018 to 19 is 1 year. 19 to 20, 20 to 21, 20 to 22, 20 to 23, 20 to 24. We're talking 6 years. 6 years. And depending on it, it may not be at 6 years, because depending on when the exact month would cross over the line for 6 months. It has to be by the month and the day and the year to be able to go for the statute of limitations. But in this state that this individual lives in, it's a 4-year statute of limitations. During the court hearing, check this out, during the court hearing, they almost admitted that the case was past the legal statute of limitations. They actually told the judge that this individual made a payment for $5. See, if they get the judge to accept that the individual made a payment for $5, guess what? It would reset the statute of limitations. They would still be within the guidelines of the law. The individual said, I do not remember ever making a payment for $5. The judge said, I don't see any records that you provided, any documents, debt collection company, that showed that payment. But I'm still going to rule in your favor. Because the individual didn't know their rights, they just ended up getting a judgment against them. Let me tell you something. If you have a debt collection lawsuit coming at you, if you do not respond to the court summons, in some cases before your hearing date, some of the judges will disregard your response. They will just disregard it because they're going to say that you did not give them, the judge, enough time, and you did not give the plaintiff enough time to review it for your defense. This individual did not have a defense, so it wouldn't have mattered anyway. But just to review it real quick, review your documents or send it to us to have it reviewed, and we will let you know what we see from experience to help you win your case against third-party debt collectors. Now, for this one here, moving forward, what we're going to do is we're going to assist this individual in reopening their case, and then we are going to help this individual put their documents together to submit that this case was outside of the statute of limitations and that they should have never even been able to bring this case. How will that be proven? It will be proven by the documents of, number one, when the actual account charged off, even though it does not matter on the charge-off date, it goes by the default, the last payment date. It does not even have to be technically in default for the clock to start ticking for statute of limitations. It goes by the last payment that you make to the original creditor. That's when the clock starts to tick, and that's when the statute of limitations clock starts to tick. And if it goes past that statute of limitations period of time according to the laws in your state, they do not have a legal remedy. But if you don't know your rights, the judge is not there to help you. The judge is there to rule on the information that is provided. So if you have a debt collector coming after you suing you in court, go to my website, thecreditrepairshop.com, in the live chat, upload your court summons, and we will review it and let you know how we can help you. If you have a case that's already a judgment, we can speak to you and see what options may be available to you with our assistance. Just go to my website, go to the live chat, punch that in there. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my point validation process and my two-phase settlement process. That's the way that we repair credit and increase scores. If you need your credit reports and scores, go to the website the3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early, before it even gets to this could have been put to bed early. Grab my statute of limitations letter. That would have put this whole thing to bed. Cease and desist collection activities letter and debt validation letter. Thank you for your time. Please subscribe to the channel. Please like this video. When you like this video for me helping you with this important information with regarding your credit and your debt, and dealing with debt collectors, you help other people. So help me continue to help you by liking this video. And by liking this video, you are also helping other people. Thank you for your time. This is Stephen A. Williams, President and founder of the CreditRepairShop.com.